Welcome to this month's Third Thursday webinar, brought to you by Synergy Settlement Services. The Third Thursday webinar is part of an ongoing free monthly webinar series. Each presentation is done by a Synergy subject matter expert who will tackle difficult issues that arise at settlement. During today's presentation, if you have questions, type them into the control panel where it says Questions. The following brief presentation will give you an overview of what Synergy does in 30 seconds.
A trial lawyer's job isn't to know all the nuances, to know what it takes to keep Medicaid in place or SSI and preserve Medicare and comply with the Medicare Secondary Payer Act and resolve these complicated liens that may be present. So all of those issues are issues that the trial lawyer really doesn't have the time or the expertise to deal with. They need a partner that they can rely upon that can handle all of those issues, and that's exactly what Synergy is.
Hello, everyone. My name is Rasa Fumagalli. I am an attorney licensed in Illinois, and I'm the Director of Medicare Secondary Payer Compliance Services here at Synergy Settlement Services. I would like to welcome you to the first third Thursday of the month webinar of the year. Today's webinar is entitled Unraveling the Conundrum of Medicare Reimbursement. At the end of the presentation, we will have 10 to 15 minutes for questions. You can post your questions in the chat box. For those who may be new to Synergy Settlement Services, Synergy offers a comprehensive suite of services that help you address all of your Medicare secondary payer compliance issues in a case. In addition to conditional payment resolution, we offer our Medicare Expert Case Evaluation, MECE Consult, as well as the preparation of allocations or life care plans. We provide Medicare Setaside administration services, trust services, structured funding, and other services as well. Today, we are going to be looking at the Medicare lien process. We're also going to examine a few cases where an attorney was held to be personally responsible for conditional payments. We're going to take a look at best practices, the Medicare lien process, ways to seek a full or partial waiver of the conditional payments, and as mentioned earlier, we will close with a question and answer session. Let's start with a general look at Medicare. So Medicare is a federal health insurance program that is available to individuals who are 65 years and older. It may be available to people that are younger than 65 if they are receiving Social Security disability benefits. There are certain conditions that qualify you for Medicare by virtue of the condition, such as end-stage renal disease. Here is a snapshot of what a Medicare card looks like. There are 4 different parts to Medicare. The traditional or original Medicare is Medicare coverage under Parts A and Part B. Part A Medicare benefits include hospital insurance. It would also include a specific period of time in a skilled nursing facility. It covers hospice care and some other home health care. There are specific requirements for this coverage. However, there's also the traditional Medicare Part B plan coverage. This covers certain physician services, outpatient care, medical supplies, and preventive services. So the way that this works is that you have physicians who participate in a Medicare program. They essentially contract with Medicare and agree to accept a specific fee in exchange for the service provided. There are also Medicare Advantage plans, and these would include plans under Medicare Part C and Part D. So the Medicare Part C plan is going to include all of the coverage that is provided under traditional Medicare, plus there may be some additional services that are included, such as vision plans and dental plans. The Medicare Part D plan is a drug plan, which covers prescription drugs. The Advantage plans are administered by private insurance companies that are paid a fixed amount each month by Medicare. The amount that they receive each month is tied to some of the specific demographics of the beneficiaries that are enrolled in their programs. For example, they would be looking at the types of comorbid conditions that the beneficiaries have that are enrolled within a specific plan when deciding how much these plans should be reimbursed by Medicare. What is interesting is that there has been a significant increase in all of the Medicare beneficiaries that have elected to enroll in Medicare Advantage plans. In 2020, 39% of all the Medicare beneficiaries were enrolled in a Medicare Advantage plan. So these plans are also using the Medicare Secondary Payer Act as their recovery vehicle for conditional payments. So let's take a look at the Medicare statutory liens. And the Medicare lien statutes are pretty complicated. The basic concept, however, is that Medicare is a secondary payer in certain situations. And Medicare is a secondary payer when payment has been made or can reasonably be expected to be made under a workman's compensation law or plan of the United States or state, or under an automobile or liability policy or plan, including a self-insured plan, or under no-fault insurance. And given this status as a secondary payer, there are also other sections in the Code of Federal Regulations that specifically list that there are exclusions from Medicare and limitations on Medicare payment. So for example, Section 411.20 specifically notes that Medicare is precluded from making payment for services to the extent that payment has been made or can reasonably be expected to be made under any of the following: workers' compensation, liability insurance, no-fault insurance. There is an exception to this when it comes to situations where a Medicare beneficiary is not able to get medical treatment because payment is not reasonably expected to be made promptly or within 120 days of receipt of the claim by the primary payer. So Medicare has indicated that they will make payment in those situations. However, that payment is a conditional payment which has to be reimbursed to the appropriate Medicare trust fund. The Medicare statutes also provide that a primary payer's reimbursement obligation to Medicare can be demonstrated by a judgment, a payment conditioned upon the recipient's compromise, waiver, or release, whether or not there is a determination or admission of liability of payment for items included in a claim against the primary payer or by other means. So the fact that a payment or a settlement is made, that fact in and of itself is enough for Medicare to claim a secondary payer status. Here's a quote from the Medicare website that discusses Medicare's recovery process. It starts out by stating that Medicare does not pay for items or services to the extent that payment has been made or may reasonably be expected to be made through a liability insurer, including a self-insured entity, no-fault insurer, or workers' compensation entity, or non-group health plan. When an accident, illness, injury occurs, you must notify the Benefits Coordination and Recovery Center, or the BCRC. By virtue of a beneficiary's enrollment in the Medicare program, they are obligated to advise Medicare when they are in an accident where another party might be responsible for the treatment. So, as noted, the Benefits Coordination and Recovery Center is the contractor that is responsible for making sure that Medicare gets reimbursed for the conditional payments. If you have a workers' compensation situation, there is a different contractor involved, and that is the Commercial Repayment Center, or the CRC. And they essentially run the conditional payment recovery process until the case settles, and there is a Section 111 total payment obligation to claimant report that is made by the workers' comp insurance carriers, RRE, or responsible reporting entity. So Medicare essentially is making this conditional payment so that the beneficiary gets the treatment that they need and they do not have to use their own money to pay for the services. As noted before, this payment is made on the condition that it is going to be repaid to Medicare when there's a settlement, judgment, award, or other payment. And this conditional payment is essentially a way to help the beneficiary after they've had an accident because technically Medicare is not responsible for this treatment. So what happens if Medicare is not reimbursed or repaid the conditional payments? 42 CFR section 411.24 clearly sets out the parties that can be pursued in that situation. CMS has a right of action to recover its payments from a primary payer, a beneficiary, a provider, a supplier, a physician, an attorney, a state agency, and a private insurer that has received a primary payment. Because Medicare can pursue all of these parties, this is why people take the reimbursement obligation seriously. Well, how does Medicare actually proceed with recovery? So the Medicare Secondary Payer Act has a provision that is called the Private Cause of Action provision, and it allows for double damages when a primary payer fails to reimburse the secondary plan for conditional payments. And the language specifically states that there is established a private cause of action for damages, which shall be in an amount double the amount otherwise provided. In the case of a primary plan which fails to provide for primary payment or appropriate reimbursement in accordance with paragraphs 1 and 2A. And this private cause of action provision is the MSP recovery vehicle that is used in situations where conditional payments are not reimbursed. There's no doubt that Medicare takes their reimbursement seriously. So let's take a look at one of the older cases where a claimant's attorney was pursued. And this is a 2009 claim called United States versus Harris. Now, Harris was representing a plaintiff who was a Medicare beneficiary. He entered into a settlement agreement with the defense for $25,000. Medicare had made conditional payments that were in the area of $22,500. After Medicare was notified of the settlement and you had the reduction for procurement costs, Medicare issued a final demand seeking $10,253. For whatever reason, the attorney did not pay and his client did not pay. So Medicare sues the attorney in federal court as a third party who received payment from a primary payer or the defendant. And the attorney filed a motion to dismiss, stating that the only thing he had to do was let Medicare know that there was a settlement. And, the court disagreed and they held that a primary plan, whether it's the insurance company, the attorney, or the other parties that we previously enumerated, can be held liable. So it's unclear why the attorney thought that all he had to do was advise Medicare about the settlement, especially when they had a conditional payment demand, which always clearly sets out what the obligation is. So the attorney in a case should really pay attention to make sure that the conditional payments that are being claimed in connection with the settlement are resolved. So we've had a continuation, though, of law firms that choose to ignore conditional payment demands. And if you fast forward here, you can see that the Department of Justice is actively engaged in pursuing plaintiff firms for unpaid Medicare debts. Let's take a look at a situation where there was a medical malpractice claim and the law firm's client received a $1 million settlement in 2015. Medicare is given notice of the settlement and they asserted a conditional payment recovery claim. The firm did not reimburse Medicare even when the debt became final by way of a final demand. And Nothing happens then for several years until we fast forward to March of 2019. At that point, there was an announcement by the U.S. Attorney for Maryland that Maryland's personal injury law firm had agreed to pay the U.S. $250,000 to settle claims that it did not reimburse Medicare for conditional payments that had been made on behalf of the firm's client. In connection with this settlement agreement, the law firm also had to designate a person at the firm that is solely responsible for paying the Medicare secondary payer debts. That person has to be a trained designated employee, and there was an obligation to review any outstanding debts with a designated employee at least every 6 months to ensure compliance. Here's a quote from the U.S. Attorney in the case. He wrote, "The settlement reminds attorneys of their obligation to reimburse Medicare for conditional payments after receiving settlement or judgment proceeds for their clients. The settlement should also remind attorneys not to disburse settlement proceeds until receipt of a final demand from Medicare to pay the outstanding debt. We intend to hold attorneys accountable for failing to make good on their obligations to repay Medicare for its conditional payments." In addition to the Maryland case, you can see that the Department of Justice has also entered into settlement agreements that we know of with at least 3 other firms in November of 2019, January of 2020, and the most recent one is August of 2020. As I mentioned earlier, at this time, about 39% of all Medicare beneficiaries are enrolled in a Medicare Advantage plan. And because of this, it is really important to be mindful that the private cause of action has been extended to Medicare Advantage plans. 42 CFR for Section 422-108F specifically states that Medicare Advantage organizations will exercise the same rights to recover from a primary plan, entity, or individual as the Secretary exercises under the MSP regulations in subparts B through D of Part 411 of this chapter. This right of recovery by the Medicare Advantage organizations is also discussed in a memo from CMS from December of 2011. This memo indicated that Medicare Advantage plans have the same rights to recover as Medicare. We have seen since 2012 litigation in this regard. The very first case that found a Medicare Advantage plan could maintain a private cause of action to recover conditional payments made on behalf of a beneficiary was in re Avandia, and that was a Third Circuit case. There was also a case in 2016 where Humana sued a plaintiff's attorney for failure to reimburse conditional payments. The court in the Fourth Circuit allowed the Medicare Advantage plan's suit to proceed in 2016. There is also the case of Humana Medical Plan versus Western Heritage, which was decided by the 11th Circuit in 2016. This case indicated that Humana was entitled to double their lien amount against Western Heritage. The case also addresses a situation where Western Heritage had actually reimbursed the beneficiary for the payments that Humana was seeking, and it was on the beneficiary's shoulders to actually reimburse Humana. So the Humana Medical Plan versus Western Heritage case indicated that a primary payer has to reimburse Medicare even though they've already reimbursed the Medicare beneficiary or other party. And that specific provision is outlined in 42 CFR section 411.24. So as a practitioner, it's important to understand the difference between a final conditional payment demand, which is a fixed amount, as opposed to an interim conditional payment number, which may change. It's also important that you realize that you cannot get information on Medicare Advantage plan payments in the same way as you can secure traditional Medicare Part A and Part B payments from the Benefits Coordination and Recovery Center. So the Medicare Beneficiaries report of a claim to the BCRC will result in the BCRC providing conditional payment information under Medicare Part A or Part B. If you want to obtain information regarding the Medicare Part C and Part D payments, you're going to have to go to the plans themselves. And another thing that you should consider and you should be mindful of is the fact that there are two different types of reporting going on when it comes to liability cases and workers' comp cases. So a Medicare beneficiary has an obligation to report an accident to Medicare, and this obligation is part of their process when they enroll in Medicare. And that is a very different type of report than the report that is done by the responsible reporting entity for a primary plan under Section 111. Section 111 reporting is a mandatory insurer reporting obligation that is placed on the defendant and the RRE for the primary plan. When a case involving a current Medicare beneficiary settles and it's a liability case involving a physical trauma and the settlement exceeds $750, the primary plan's RRE is going to make their Section 111 total payment obligation to claimant TPOC report. Another thing you have to be aware of is that when you have a case that has actually been in your office for an extended period of time, it's quite possible that you may have a situation where your client, the Medicare beneficiary, has enrolled in different plans over the life of the claim. He may start out enrolled in a traditional Medicare Part A and Part B plan. 3 years go by, he may switch over to a Medicare Advantage plan. After another year or so, they might switch back to traditional Medicare, or they may enroll in a completely different Advantage plan. So it's important to stay on top of the different types of coverage that the Medicare beneficiary may have over the life of the claim. There's some things you can do to help make the conditional payment process go more smoothly in a claim. I would recommend that you request copies of your client Medicare beneficiaries' health insurance cards once you sign them up. It's also a good idea to request updated information during the life of the claim. The medical records should be reviewed to see who is being billed at various times over the years of treatment. You should also be able to see the billing statements in the pharmacy records. It's a good idea to begin this investigation early. If your client does not remember the various plans that they've been enrolled in when it comes to Medicare, I would suggest that they open up and they register an online account on mymedicare.gov. It's a pretty good website that will show the different plans that your client was enrolled in once they became eligible for Medicare. The Provide Accurate Information Directly Act, also known as the PAID Act, was passed into law in December of 2020. What this PAID Act legislation does is that it requires CMS to provide information upon request to a non-group health plan regarding a beneficiary's enrollment in a Medicare Advantage plan or a Medicare Part D plan during the preceding 3-year period. And this information is going to be accessible through the Section 111 reporting database. And even though this information will be provided to the defendant, to the primary payer that is doing the Section 111 reporting, as I mentioned earlier, you as a person who's representing the Medicare beneficiary could access this information through mymedicare.gov. But it will now be easier for defendants and primary plans to identify the various Medicare Advantage plans that may have an interest in seeking reimbursement of payments that were made. At this time, we are now going to switch over and start looking at the actual Medicare lien process. So anyone who has ever dealt with Medicare liens in the past would have to agree that it is a very time-consuming process, and it's also quite frustrating. There are many different parts involved in securing the final conditional payment information. There are also deadlines. If you have any issues or problems with securing the conditional payment information, it's very difficult to get an answer from anybody when you call on the phone. Oftentimes, you're also going to get conflicting information. This conditional payment recovery process is also complicated by the fact that you may have the defendant's responsible reporting entity reporting conflicting information when it comes to the injuries that were settled, the dates of loss, and that is especially true in a medical malpractice claim where you can have different accident dates that people are using. So in order to try to make that piece a little bit more efficient, it is beneficial at times for plaintiffs and defendants to actually agree and confirm that a specific accident date will be reported and that the settlement is involving a specific condition. The next few slides are going to address the Medicare lien process. The information has been taken from the Medicare website, which is pretty decent when it comes to Medicare secondary payer information. So the way that you initiate the Medicare lien process is to have the Medicare beneficiary report the case to the BCRC. And this reporting obligation kicks in whenever there's a pending liability, no fault, or workers' comp claim. The report of the claim is the very first step in the whole Medicare secondary payer recovery process. The information that you're going to have to report is going to include your client's or the Medicare beneficiary's full name, Medicare number, gender, date of birth, complete address, and phone number. You are also going to have to share information regarding the type of claim, the insurer or workers' compensation carrier's name and address, the description of the alleged injury, illness, or harm. And I would recommend that there actually be a discussion and some coordination to make sure that the injury which is being reported is really one that can be tied into the accident. And of course, you are also going to have to report the date of the injury or the accident. The Medicare Secondary Payer Portal is a very helpful tool when it comes to conditional payment recovery. Synergy uses it often. You can actually provide this first report via the Medicare Secondary Payer Recovery Portal, and here is a screenshot of what it would look like. Once the initial Medicare Secondary Payer Occurrence event is posted, the BCRC is going to send the beneficiary the rights and responsibilities letter. It essentially explains how the recovery process works and what information is going to be needed from you and what information you can expect from the BCRC. This is a screenshot of what the letter looks like. The next thing that happens is that Medicare is going to start looking at payments that were made in connection with the diagnosis code or injury that was reported to them. So they are going to start their search from the date of incident, and they are going to provide a temporary figure which is subject to change, and this would be called the conditional payment letter. Here is a screenshot of what the conditional payment letter will look like. As you can see, the letter states that, for example, as of the date of this letter and based upon available information, Medicare has identified $2,795 in conditional payments that we believe are associated with your case. Further down in the report, it talks about that they are still investigating the case to obtain any other outstanding Medicare conditional payment information. And it specifically indicates that this information is not final. So when you receive a letter like this, you should not rely on this figure as being the final figure. It clearly states that this is an interim figure. This is what a payment summary form looks like. As you can see, it has different line items and they reflect the ICD diagnosis codes that were treated. It's important to review the codes to make sure that they're consistent with the type of injury that is alleged in the claim. Medicare is also notorious for including all sorts of unrelated diagnosis codes. So beware that just because Medicare wants to be reimbursed for it, chances are that it really doesn't have anything to do with your claim all the time. As I mentioned earlier, the Medicare Secondary Payer Recovery Portal is a nice tool that allows the conditional payment recovery process to flow a bit more smoothly. These are some of the features that are available through the use of the portal. You can essentially submit the proof of representation, the beneficiary consent to release, or the insurer letter of authorization. You can request conditional payment information. You can request copies and actually print out the conditional payment letters that were issued in the claim. You can also dispute the claims. These are some other things that you can do on the portal as well. You can initiate a demand letter. You can submit case settlement information. You can also submit a waiver, compromise, or redetermination request. There are other options when it comes to conditional payment amounts. There is the self-calculated conditional payment amount, which is available under certain specific facts. It only applies to physical trauma-based liability settlements. The settlement must also be less than or equal to $25,000. The date of incident also has to be at least 6 months prior to submission of the self-calculated amount, and there are also specific timelines that must be followed. The fixed percentage option is also available for physical trauma-based liability settlements. This feature is available when the settlement is less than or equal to $5,000. There are also specific timelines associated with this option. Sometimes Medicare does not issue a conditional payment letter and they instead issue a conditional payment notice. This usually happens when there is a Section 111 total payment obligation to claimant report by the defense or the responsible reporting entity. And this is issued when a settlement, judgment, award, or other payment has already occurred. So if there is a conditional payment notice, it's really important to respond to it within 30 calendar days. If you do not respond to it, then you are going to get a demand letter and they are not going to give you a proportionate reduction for fees or costs. So when you receive a conditional payment notice or a conditional payment letter, there are ways to dispute the claims, and the basis for the dispute would be to request a removal of the charges because they are unrelated to the claim. You can do the dispute through mail, through fax, or through the Medicare Secondary Payer Recovery Portal. If the BCRC agrees with your dispute, they will send an adjusted conditional payment amount. When the case fully settles, there's an obligation on the part of the beneficiary to report the settlement, judgment, award, or other payment to the BCRC. There are specific things that have to be reported, such as the date of settlement, amount of attorney's fees and other procurement costs that are borne by the beneficiary. And there is a final settlement detail document that can be used to make this easier. This is what the final settlement detail document looks like. So once the case has fully settled and Medicare issues a final demand, it's important to realize that the conditional payment demand may include charges that were not reflected on the conditional payment letter, they're essentially going to do another database sweep from the date of accident to the date of the settlement, judgment, award, or other payment. And once this final demand is issued, there's going to be a formal recovery demand letter that is sent by the BCRC seeking recovery of the demand amount. Once you have the demand, the options are to either dispute it or pay it. If you do not repay the debt or dispute it within 60 days, you are, or whatever time frame may be reflected if the process changes, interest is going to be assessed for each 30-day period the debt remains unresolved. And interest is going to accrue on the outstanding principal portion of the debt. If you appeal the demand, interest is still going to accrue. So really, Medicare recommends, and from a practical aspect, it is recommended that you consider paying the demand so that you can stop the accrual of interest. And if you prevail on the waiver or appeal request, you will receive a full refund. If you do not act on the demand letter, what is going to happen is there is going to be an intent to refer the debt to Treasury. And the intent to refer is sent on day 90 after the date of the demand letter if full payment is not received. And the CMS may then also refer the debt to the Department of Justice for legal action. As I mentioned earlier, the private cause of action allows for double damages in situations such as this. There are two ways to reduce the final demand. There are reductions for procurement costs. One is to simply reduce the fees and costs from the Medicare lien amount. And the second is to reduce the fees and costs from the settlement, and the remainder goes to Medicare then, essentially leaving nothing for the plaintiff. So these two methodologies, however, do not take into account any liability-related issues, such as caps on damages or low policy limits and so forth. The goal of the Medicare secondary payer statute is really to maximize the return of the funds to Medicare. They are not really concerned about the well-being of the Medicare beneficiary. The next two slides provide the statutory basis for this type of reduction. So what other options are there for further reduction? So there's option one, which is submit an appeal. If the final demand remains unpaid, you're going to have interest accruing. The other option is to pay the final demand, and the benefit to this is that the interest stops accruing while you are requesting a waiver or a compromise. Basically, three statutory provisions under which Medicare can accept less than the full amount of the final demand. The first is a financial hardship claim, which is evaluated by the BCRC and can be pursued under Section 1870C of the Social Security Act. The second is a waiver for best interest evaluation that occurs by CMS pursuant to Section 1862B of the Social Security Act. And lastly, there is a compromise request which can be presented under the Federal Claims Collection Act, which is also reviewed by CMS. The financial hardship request for a full or partial waiver looks to the statute, which states that there shall be no recovery if such recovery would defeat the purposes of this chapter or would be against equity and good conscience. Under this section of the Social Security Act, the BCRC is able to grant full or partial waivers to beneficiaries when repayment of the conditional payments would pose a financial hardship. In order to apply for this, the Medicare beneficiary is going to have to file a form with the BCRC, which documents their financial situation. Synergy also recommends and includes a letter that is drafted by the Medicare beneficiary, not their attorney, explaining the undue hardship that repaying Medicare would cause. There's also the best interest of the program waiver request, which can be made. As mentioned earlier, this is reviewed by CMS under the provision that states that the Secretary may waive in whole or in part the provisions of this subparagraph in the case of an individual claim if the Secretary determines that the waiver is in the best interests of the program established under this title. The compromise option under FCCA gives the federal agency the authority to compromise where the cost of collection does not justify the enforced collection of the full amount of the claim. There is an inability to pay within a reasonable time on the part of the individual against whom the claim is made, or the chances of successful litigation are questionable. Synergy has been extremely successful in presenting these various arguments to CMS and to the BCRC. For example, in one of the cases that we handled, we had a slip and fall case on a parking curb. The Medicare beneficiary sustained a broken wrist, a broken pelvis, and a bruised kidney. The round-the-clock caregiver expenses were paid out of pocket. The case settled for $115,000. Medicare's final demand was in the area of $22,000. Synergy extended and offered a compromise of $100, which was accepted by CMS. So the claimant essentially got a refund of $22,310.72. Synergy also had a 100% recovery in a case where there was a medical malpractice action. The Medicare beneficiary's income was quite low. The request that was made was a financial hardship waiver. The Medicare beneficiary was caring for her daughter and her granddaughter, and she was essentially paying for them. The settlement of $300,000 was reduced to a net settlement of $157,000 after fees and costs were deducted. Medicare's conditional payment letter was $73,000. They made a final demand of $38,000, which was actually paid. When Synergy presented a financial hardship waiver request, all of the funds were reimbursed and they were placed in a special needs trust. When it comes to conditional payments, Synergy provides a Medicare audit and verification service to our clients. We essentially take the Medicare reporting and auditing process off your plate while you focus on what you do best. We are making sure that the injury victim is able to retain as much of their settlement proceeds as possible. Other things that we do in addition to the waiver and compromise options, which we just discussed, is we are able to work with you to secure final conditional payment information prior to mediation or settlement using the final conditional payment process through the Medicare Secondary Payer Recovery Portal. Synergy's waiver compromise refund service has a very good track record for success. The way that we're able to do this is we review the case on the front end, and based on our expertise, we can usually tell whether or not we're going to have a successful result or not. After you pay the final demand and your case is technically closed, we can work on behalf of your client seeking a refund. Any refund which we can achieve is actually an unexpected gift to your client. So that is a win-win for all that are concerned. So now we've reached the end of the slides, and let's see if there are any questions. Thank you for your time.
All right, everybody. So let's take a look at the first question that we received. The question was, what is the difference between a supplemental plan and an advantage plan? And the difference is that a supplemental plan is something that you would purchase as a Medicare beneficiary to essentially supplement the benefits that you're receiving under Medicare Part A or Medicare Part B. So the supplemental plan would pay for co-payments, it would help pay for deductibles, it would also help pay for perhaps certain services that original Medicare wouldn't cover. A Medicare Advantage plan on the other hand, is not paying these additional costs. A Medicare Advantage plan will pay for benefits under Medicare Part A, Part B, and additional benefits. So these are separate and distinct types of policies. All right, let's see. Next question. What about a Medicare beneficiary on SSI who did not use Medicare but went through a private doctor on a lien basis for an injury case? So a conditional payment is only a payment that was made by Medicare prior to settlement that is injury related. So if the Medicare beneficiary did not present any services and the provider didn't bill Medicare, there is no conditional payment. If the person is receiving a Medicaid type of benefit because they are on SSI, there may be a different sort of reimbursement or coordination of benefit obligation that will possibly differ on a state-by-state basis. The other second part of this particular question too just talked about whether we can provide assistance in setting up special needs trusts or pool trusts to make sure that a person does not lose their ongoing eligibility for this public income-based benefit. And yes, we do have a pooled trust service that we provide through Synergy Settlements. All right, here's another question. At what point during the claim can the RRE request Part C and Part D information under the PAID Act? Must it wait until the case settles, or can it request the info at the beginning or in the middle of the claim? Can it make the request more than one time? And these are great questions. And the PAID Act, though, was just signed into law in December of 2020. And Medicare has 1 year in which to implement it. Chances are it's actually going to take them longer. So the National Medicare Secondary Payer Network is actively engaged in discussing, the sorts of things that Medicare may want to consider when they actually go about coming up with this process for the PAID Act. So at this point, we really don't know. It hasn't been implemented yet. And if Medicare is actually on schedule, we should have some information by the end of the year. And let's see. All right. Okay, here is a question. I have a case where the beneficiary has died. Is Medicare willing to consider a partial waiver for the benefit of the heirs? And the experts at Synergy who actually deal with these day-to-day sort of discussions with Medicare have indicated that it's only likely to happen if the heirs are actually true dependents of the beneficiary that died. Okay, let's move on and see. Can you comment on Medicare Advantage plans and Medicare set-aside agreements? Yes. So a Medicare set-aside allocation, and now I'm going to discuss this in the context of a liability case. A Medicare set-aside arrangement will include future injury-related Medicare-covered expenses. So it's going to be a specific dollar amount, and technically, those funds should be used before Medicare is billed. If the Medicare Advantage plan is given the same rights as Medicare when it comes to recovery of conditional payments, then presumably those MSA funds should be used instead of billing the Medicare Advantage plan. So I believe that technically the correct answer in the eyes of Medicare would be to use the MSA funds as the primary payment for injury-related Medicare-covered treatment rather than billing the Medicare Advantage plan. On a practical note, we have been aware of situations where actually the Medicare Advantage plan is billed even post-settlement when you have an MSA and the MSA funds are there in case there's an issue with reimbursement or a claim by the Medicare Advantage plan down the road. So there are several different ways that you can look at this and you can analyze this. All right. Where can training about Medicare BCRC process be found for law firms? Well, one of the places you can find information regarding the Medicare BCRC process is to actually look on our website, but you can also go to the Medicare website, which is the Benefits Coordination Recovery Center website. Has a ton of information about how plaintiff's attorney can actually obtain information on the process for conditional payment recovery. All right, here is another question. To clarify, does Medicare need to be notified of the accident? So if your client is a Medicare beneficiary, when they signed up for Medicare, they were advised of certain rights and responsibilities. And one of the responsibilities that they have is to notify Medicare when they're receiving treatment that is due to a third party. So there is an obligation for the Medicare beneficiary to sort of do a self-report so that the conditional payment search process could be initiated. And now that obligation to report on the beneficiary is separate from the mandatory insurer reporting obligation that is placed on the defendant in the claim. So okay, so the part 2 of a question, which I had answered was, okay, here's the question. If client went to a private doctor and never used their Medicare, it's on a private lien. Do we need to notify Medicare of the accident if we know 100% Medicare did not pay? Technically, you really should notify Medicare. If you are settling this claim, the mandatory insurer reporting obligation will result in the primary plan notifying Medicare of the settlement as well. So I don't see any downside in terms of the Medicare beneficiary actually complying and giving notice of this accident to Medicare. Okay, let me see. All right, here is my understanding was Medicare would pay, but then wants recovery. I suspect provider is just saying Medicare won't pay in order to get the full retail amount of their bill paid, which doesn't give the client benefit of the reduction. Okay. So a Medicare provider really should not bill Medicare initially when there is an accident. But they also, I believe, have the option to seek reimbursement from the recovery of the litigation or the settlement. So this question about, the provider not giving the client the benefit of the Medicare reduction, I'm not quite sure. I mean, the provider would actually be able to choose, I believe, whether they want to bill Medicare or if they would rather just let there be a lien situation. So here is another question about when do you need to worry about a Medicare set aside? And I'm not sure if this is related to this question, but the question says, is an MSA required when the client is covered by a Medicare Advantage plan? So because the Medicare Advantage plan is considered to be Medicare under purposes of the Medicare Secondary Payer Act, any party that settles their claim should avoid a cost shift of future injury-related expenses to Medicare. And one of the ways that you can do this when your settlement releases future medical, it funds future medical, and you've claimed future medical, is to actually apportion some of the settlement proceeds for this future injury-related Medicare covered treatment. And whether you actually choose to use those funds to pay for treatment rather than billing the Medicare Advantage plan, or you bill the Medicare Advantage plan and you have these funds carved out, that is your choice. It's also your choice to decide, well, should I actually try to apportion any of my settlement? Because my client is enrolled in a Medicare Advantage plan, they do have this other coverage. The Medicare Secondary Payer Act is the law that provides the framework for why there is a potential or there may be a potential issue with Medicare denying payment. So, Medicare is prohibited from making payment when payment has been made or can reasonably be expected to be made under a workers' comp plan, a liability plan, or a no-fault plan. And payment is defined by a settlement. So there is this prohibition from Medicare making payment for injury-related services that were compensated in the payment that was made. I think the most important thing is to have a discussion of the Medicare Secondary Payer Act with a Medicare beneficiary at time of settlement. The pros and cons of different approaches can be discussed, and really your client should be making an informed decision about, well, do they just want to keep billing the Medicare Advantage plan and see if anything happens, or would they rather take a different approach in the particular case? Okay, so at this time, we are out of time, but I do see there are several questions which I have not answered. So we will be sure to get back to everybody offline. I appreciate your time and I hope to work with you in the future. Thank you.